Correct.
So it's possible you got that from him.
It's possible. It's possible she told me. I don't have a record.
All right, so it looks like, Jonna, this testimony is about to wrap up here. I'm curious, we haven't had your opinion on this yet. She is being allowed to testify. We talk about recollection refreshed. Now, again, every state's different, but typically speaking, I didn't hear them go through, even in a preliminary hearing or outside the presence of the jury. One of the factors, and I kind of pulled it up real quick here, is that they have to say that that is something that they recall saying and that it's accurate before the judge can make a determination as admissibility. Now, whether there's been a pretrial ruling here or the defense lawyer doesn't want to fight it, what's clear is that the cross of the defense lawyer, they're trying to get out this idea to rebut the prosecution's argument that she wasn't suicidal by saying you were really not that close and she didn't tell you all these intimate details. Do you think that that was relatively effective?
I think the defense is making some points here. I actually have to question, if I were prosecuting this case now, would I have called this particular witness again? Because she doesn't have a lot to offer. I mean, she's supposed to be poking holes in the essence of the defense, which is suicidal. But she's not doing a great job for a couple of reasons. And she's coming by it honestly. She just doesn't remember. It's been a couple of decades, number one. And she does come across as credible in the sense that, you know, she honestly doesn't remember. She's trying to use the benchmarks. You know what was most telling to me, Bob, is when she was asked the question, you weren't that close, were you, by the defense attorney, she took a very long pause. And to me, that was more of an answer than when she said, well, I guess maybe not. Like, the jury's going to hang on that, because if you're close with somebody and someone asks you your status, of course, that was my best friend. We talked all the time. Not, and then 10 seconds of silence. So very interesting.
A little bit, but I'm going back to me being a prosecutor, because that's where most of my cases were tried. I don't want witnesses saying, I don't remember, I don't recall, it was a really long time ago, because I know a defense attorney is going to get up there and say, hey, I'm really sorry about all that, but my client's guilt or innocence and very significant consequences flow from a guilty verdict, and if they don't remember, and it is a long time ago, shame on them. That's their problem, not ours. That would be the argument I expect to hear.
And I would expect to hear it too. And I thought it was very interesting that she's trying to put a frame of reference based on the childhood of, I guess, this defendant's one of his kids. Like, well, he was a toddler back then, which is also very interesting, because if you're a juror listening to that, you're going to give that kind of testimony a little more credibility, I would think, because it's not some sort of rote memorization. She's saying, I remember the kid being in diapers, and that's when I knew, you know, so-and-so. So I think that was interesting that she tried to frame it that way. And I wouldn't be surprised if that was due to some conversation that she might have had with anybody who was trying to prepare her for her testimony today, which, since she's not represented by an attorney, would not be privileged. So that might be something that comes up on cross-examination.
And that's a great point, Brian. I mean, the silence was one thing, but then she started going through in her mind the definition of what a close friend could be. Well, you know, we wouldn't really trade intimacies. And that's exactly what the defense wanted there. So when you're saying that she wasn't suicidal, you don't know about everything that was going on in her background. We can only surmise the prosecutor called this witness to try to rebut the defense's argument about suicide. Did you think it went well? How do you think the defense lawyer did?
I think the defense is doing a good job on this point, but I also feel that this is, you know, going to be up to juror determination, and one juror sitting next to the other might view it differently. On the one hand, during her direct, she said, you know, she thought that the woman was just generally unhappy. You know, and then in the cross, we see this issue come up. So it really is going to be a question of how it's received. But, you know, listen, both sides are working with what they have. The reality is this case is 25 years old. The witnesses didn't testify about this in decades, okay? So this is what it looks like when you have an old case, you know?
Yeah. John, I want to ask you, you know, get to the point here. Just so we're clear, the evidence with respect to the grave letter or whatever, the letter from the
letter
victim,
from the grave.
that letter from the grave is not going to be admitted in this case. That's the basis upon which it was reversed in the first place. Again, in most states, that letter typically, in my estimation, my opinion, I've had them, would never be admitted because you can't cross-examine the declarant of the letter. But what are your thoughts about the fact that that has caused such a significant delay delays never favor the prosecution.
Right.
Obviously, it's giving him another bite at the apple, and from that standpoint, I'm sure the defense sees that alone as a success.
Oh, absolutely. And look, this defendant has really nothing to lose by doing this. He's got nothing but time. He's got time on his side because evidence doesn't get better with time. Memory fades as we're seeing firsthand right now. And the fact that a critical piece of evidence that convicted him is not going to be admitted into this case, it almost makes me wonder if there was any talk to negotiate some sort of resolution without having this second trial. That's something we'll never know. That's just what we attorneys usually do.